So I'm going to record this presentation and it'll be available on just on my YouTube channel as well in case somebody didn't get to watch it or you had to leave early or something. At the end of this presentation, please make sure to complete the survey. So the survey will let you get the credit for this. And so just make sure that we get that done. So I've got your name and your email. If you have more than one person who is sitting there with you uh, and is really sitting there with you, then make sure and put their name and email in there as well, and so I can send you all of the certificates that you need. So um, let me share my screen here. All right. So, my name's Frank Flasspohler. I think probably most of you know me, but I'm the attorney for EMS Legal Services that was started by Mr. Frank Foster, and I have continued in his stead. Work with quite a few ambulance districts around the state of Missouri. Very fortunate. I've actually been an EMT longer than I've been an attorney. But very fortunate to get to work in EMS and with all of our EMS partners. I also represent a collection of 911 districts and then some fire protection districts as well. So very grateful for the opportunity to serve as legal counsel to so many wonderful men and women who are providing our emergency services in the state. So this morning, I want to just kind of go through about 50 minutes, a little webinar here for about mutual aid agreements. The primary focus of this webinar is for EMS mutual aid agreements. And so certainly I'll mention 911 MOUs at some point, and then fire protection mutual aid agreements have some similarities, but we're really going to focus in on EMS today. I want to start off by thanking the Missouri Ambulance Association that provides the opportunity for us to get the continuing education credit for our EMS administrators and for our not our EMS board members. And so, thank you to the Missouri Ambulance Association. They're celebrating their 30th year this year of providing that leadership in the state of Missouri. Very grateful to them, and they had a wonderful celebration this past last month down at the Lake of the Ozarks. So I just want to give them a special shout out. For those of you who've been to my webinars before, or any of the presentations, I always like to start talking a little bit about my family. And so I thought I'd just show you some of the pictures I have that we've taken over the last couple weeks. This has kind of been our summer. Certainly, family is the most important thing to me. And so I always like to talk about them every chance that I get. And so just last week we got the opportunity to go to Six Flags, and so actually Mr. Nick Jennings, who is you may recognize his name. He is the AI guru for St. Francis County Ambulance, and if you ever have any questions about AI, I would certainly reach out to Nick because he does some really wonderful work. But he and his wife and two kids were able to join us in St. Louis. And so we got to go to Six Flags where the lines were absurdly short. I've never ever been to an amusement park where there were not lines, and so that was wonderful. We got to ride lots of rides. There in the middle, actually the week before that, we got to meet up with Josh Kroll, who is the administrator in Osage County. And Josh met us down at, I still call it Six Flags. I think it's Super Splash USA or something down at the Lake of the Ozarks now, but always will be Six Flags to me. So we got to play with the kids there. And then the up at the top, we went, of course, my daughter, who's quite the runner, she loves to run every chance she gets. We did a little 5K in Herman at the winery. And I love Herman. It is a beautiful place. Absolutely an awful place to do a 5K because there are so many hills. But nonetheless, we survived. It was a really pretty jog through the winery there. So, and then the other two pictures, we went down to New Orleans for a couple of days, and so my kids got to go fishing off the Gulf of Mexico. They called it a Gulf trip to go out fishing, and you can see how far we were from the shore there in that picture. But all the kids had a really great time fishing. You'd see Abby and Gracie there with their fish. And actually, Matt Bowen from Lynn County, he joined us on that as well. And then down there in the corner, that's Madison. I was at the Children's Museum there in New Orleans, so we had a great time. Today, during our webinar, the things we just kind of want to go over, I've got just kind of four highlights that we want to talk about in looking at mutual aid agreements. And so we're going to start by looking at four statutes, so four of everything today. Four of the Missouri statutes that really kind of focus in on mutual aid. I want to just take a look at each one of those, talk a little bit about what goes into them, how they're very complementary, but maybe how they're a little bit different and what they focus on. Then we want to spend most of our time talking about some of the elements that need to be part of our mutual aid agreements. And so we're going to talk about command and control, about liability and indemnification, about how workman's compensation and insurance and reimbursement all play a part in that, and how they really are things that we need to make sure we're taking a careful look at in these mutual aid agreements, especially in these written agreements, because we can go online and we can get copies of agreements, or we can reach out to our fire partners and get the agreements that they use. But there are some unique things we want to pay attention to in EMS. And if we just go and grab another mutual aid agreement that's not specific to EMS, then we can sometimes get into trouble. So there are some models out there that we can look at that certainly I would direct you to pay attention to. And then obviously you can always talk with your attorney, with legal counsel, to really make sure that as you pull from these models, that it's specific and it does what your agency needs it to do. So the State Emergency Management Agency has some models out there. There's a sample agreement from SEMA. Annex C is part of the State EMS Mutual Aid Plan, so you can take a look at that one as well. That has some very good provisions in it. And then there's some interstate compacts, and then just, maybe also some regional mutual aid agreements. So I know the Missouri Regional Council in the Kansas City area has a great agreement in place, and so sometimes those regions have some agreements that can be very helpful. And then finally, we just want to close out. I've got four kind of points that I want you to walk away with, things that we can monitor as we go forward, kind of your takeaways from this morning's presentation. So let's kind of start off by talking about why mutual aid agreements matter, right? Because, we in EMS have always helped each other out, right? And when our neighbors call, certainly we send a truck or we send two trucks or whatever we do, we respond in the emergency. And so when we get that 2 a.m. call for the tornado in a neighboring jurisdiction, certainly, we don't ever hesitate to send our folks there to help cover those emergencies, that response. And so we may have multiple agencies that respond to a significant disaster or emergency situation. And of course, in those situations, nobody ever hesitates, right? Everybody shows up, and operationally, we do an amazing job. Missouri EMS, I think, has always been really solid on mutual aid. The concern is, when I have to put my legal hat on, that when we're six weeks down the road, after all that dust is settled, then maybe that's when we can start to see some issues that come out of our mutual aid responses. We've got a patient or a medic who suffered maybe a back injury while they were in mutual aid, and now they file a workman's comp claim. Well, whose workman's comp insurance is going to cover that? Who was she working for at the time? Is it our district? Was she working for another district? Whose workman's comp is going to pay there? Or maybe one of our ambulances hits a power line or a power pole, or is damaged. Maybe we lose a monitor, falls in the river, and is gone. Well, whose responsibility is that monitor? Who is going to whose insurance provider is going to cover that collision? Or we go on this call, and then down the road where the agency maybe where the disaster hit, and then we get our neighbors to come, and a couple months later, all of a sudden we get a bill for $15,000 for a mutual aid response for the overtime and the fuel and the expenses for that assistance that was never really discussed prior to that. So those are things that certainly we need to be aware of. And then, of course, who bills the patients? So we may have mutual aid responses and we may have ALS intercepts. We need to understand who's going to bill for those transports so that we don't both bill for it, right? And then suddenly we've got Medicare wanting money back from somebody because we should not have billed twice for that run. So the point of this webinar is really that mutual aid, especially in EMS, basically never fails operationally, right? There may be some hiccups out in the field, but when we're working together in responding to an emergency, there's almost never an issue. The opportunities for failure in mutual aid come after the incident, and they are legal. They can be financial. When insurers, auditors, attorneys, whoever it is afterwards starts getting concerned about what happened, and so we can have written agreements in place, and a well-drafted agreement can really address those concerns in advance. And so certainly we always want to respond and help each other out, but just relying on that handshake agreement is oftentimes not enough on the back end. So let's take a look at the Missouri statutes that kind of codify some of the aspects of mutual aid. I did not include the natural disaster that allows the governor to, of course, activate in a natural disaster, excuse me. But definitely kind of falls still within that statewide mutual aid aspect. And so the most basic provision, there's some provisions in our state constitution about intergovernmental cooperation and working together. The most basic statewide statute applicable to mutual aid is in Chapter 44, Section 090. And it's really the backbone for the statewide mutual aid system. It includes all ambulance districts and really every political subdivision that's involved in patient safety or public safety is automatically part of this statewide mutual aid. The statewide mutual aid system does require the practice of the National Incident Management System, or NIMS, and it grants protections for emergencies, for those natural disasters, and basically, takes some of those provisions to ensure that the same protections we would have in responding to our own emergencies apply to those mutual aid. Um, the it does allow agencies to opt out if they want, but they have to do so by a formal resolution. And so certainly your board, if it does not want to participate in statewide mutual aid, and I would discourage that, but if for some reason they don't want to do that, they would need to do that by a formal resolution, because otherwise there's the legal presumption that you are participating in the statewide mutual aid system. In addition to Chapter 44, Chapter 70, Section 837 is another emergency aid statute. It is particularly important for those jurisdictions that are along our borders with neighboring states. And it provides essentially that emergency aid, mutual aid authority that allows us to cross state lines to help other agencies that might be just across the border. What we really want to hone in this morning, so we're going to talk a little bit about the 44090, but Section 190, of course, point 107, Chapter 190, that's our ambulance district provision, is really our statute, right? It's written specific for ambulance services, but although Chapter 190 focuses on ambulance districts, this specific section 107 includes all ambulance services, whether we're a district, municipal service, a fire protection district that's running an EMS and running an ambulance, or a private company. And so this 190.107 allows all of those entities to contract for mutual aid. And it even does extend to allow those contracts with neighboring states, with neighboring agencies across state borders. So if you are a fire-based EMS system, of course, Section 320.090 is in our fire chapters, and it really kind of just applies to those fire protection districts that might be providing EMS service. All of these statutes are important because as we're drafting our agreements, we really want to make sure our agreements are referencing the appropriate statute, because it's kind of almost like showing your ID. It explains in the agreement where we're getting the legal authority to enter into these written mutual aid agreements. And so, as I said, if we're an ambulance district and we borrow from our fire partners, or we're a fire-based EMS agency and we borrow from an ambulance district, we don't want to be citing a statute that doesn't apply to us and therefore does not give us any actual authority. So I mentioned Section 44.090 as the statewide mutual aid system. It creates that automatic statewide system, right? And so a very, I think probably out of the statutes we look at, it's the longest statute, extends to everybody who is providing any sort of public safety response in a disaster. It includes three pretty important provisions, and so it grants license reciprocity during emergencies, which means that your licenses, when we're going and responding somewhere else, are treated just as if they were, as long as they're valid from your home jurisdiction, they're treated as if they're valid in the jurisdiction you're responding to as well. And so when you go to an emergency, or an authorized drill, because the statewide system, this statute does apply to drills as well. When you're responding, nobody has to get relicensed to go and help their neighbor. So pretty good protection there. There is a provision in the statewide mutual aid for reimbursement, indicating that they should receive appropriate reimbursement. That's kind of a provision that's in there so that if there's FEMA funding or statewide funding, we're going to ensure that if there's reimbursement out there, that can trickle to the partners that are participating in that statewide response. And then finally, one of the key portions of the statewide statute are that our employee benefits follow our responders. And so if our medic is hurt or injured in another jurisdiction, the benefits they would normally get if they were responding at home, like workman's comp, like the line of duty death benefits, really all of those benefits follow them across the jurisdictional line. So anywhere we're going, we're ensuring that our employees get that same protection. Likewise, they get that same liability protection. And so if they're responding in an emergency as part of the statewide response, we've got that liability protection, that sovereign immunity, that official immunity, that public duty doctrine, all things that are following our responders as we go. And so I do want to point out and just remind you again, this is a system where we are automatically enrolled. And so unless your board has provided a written opt-out, this is automatically every public agency or public safety agency is already a part of this statewide mutual aid system. However, That doesn't mean that you shouldn't also have written agreements. And so please do not just let that be the 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 default, right? Because we certainly still want to have written agreements. In our written agreements, there are a couple things that we want to make sure are in every written agreement because these are required by statute. So every mutual aid agreement that has an indefinite term, and most of them have indefinite terms, right, or automatic renewals, every mutual aid agreement can always be canceled with that 60 days of minimum notice, saying that before we cancel a mutual aid agreement, a written agreement with one of our neighboring partners, we have to give them that 60 days notice. There also should be a provision in your written agreements that indicate that mutual aid is never a substitute for staffing. And so your agency is required to maintain the staffing that it should have. We can't draft these mutual aid agreements and then that's going to carry us over where we don't have to worry about appropriately staffing our agencies. So we can't brown out a station or reduce staffing because we've got mutual aid in place. And I would suggest that there be a recital, maybe one of those whereas provisions in your agreement that makes that clear. Because again, these are two things that are referenced in almost all of these statutes. So section 44.090, 190.107, and 320.090 all reference both the 60-day cancellation notice and the prohibition on using it as a substitute for staffing. And if it's not recorded in that written agreement, I think there is the risk then that a court could find that you have not met the legal requirements for the agreement and could throw that out because the court could basically say it's facially non-compliant, right? That it did not meet the statutory standard. And so these are two pretty easy things to make sure that are in there. Uh, I do want to point out, so in section 44.090, there is a provision that talks about without a written agreement. And so I just want to mention that because it says that the highest ranking official of any political subdivision or public safety agency, and of course that includes all of us that are probably on this call today, certainly all of our ambulance, fire protection, law enforcement agencies, but EMS and any ambulance service is going to be within that. The highest ranking official, even without an agreement, can participate in mutual aid um, as long as they are in accordance with the policies and procedures set forth by their governing board. And so, in addition to a written mutual aid agreement with the partners that we are routinely responding with or mutual aid assisting, every political subdivision, every ambulance district should have a board level policy. And so I know in many of our jurisdictions, maybe for especially like personnel policies, the board has delegated to the district administrator the ability to adopt personnel policies or adopt vacation policies, and those don't necessarily have to be approved by the board. That's great. I think that's wonderful. I think our administrators are the best people to write those, and I don't think that the board needs to necessarily be approving every individual policy. This is one of those exceptions where the board absolutely has to approve your mutual aid policy. And so your board should have a policy outlining the authority of your administrator to respond to mutual aid. So when they're going to, under what situations they'll respond, how they have to get approval, how they can respond, maybe guaranteeing or ensuring a minimum coverage. So if we have some policy in place, and I'm using policy very loosely there because I like to distinguish between policies and practices, right? Because a policy is something that is in writing, that you can go to the shelf, pull it out, and say, right here, this is our district's policy. A practice is something that we've done for the last 30 years, and everybody knows this is what we do, but it is not a policy. So please make sure that your board has adopted a policy regarding mutual aid because that's really going to protect our administrators, uh, of which most of us are, in ensuring that they are covered when we're authorizing those mutual aid responses. All right, so let's then turn to section 190.107. And this is really the EMS specific statute, right, that comes to us from chapter 190. That is focused in on ambulance districts and EMS mutual aid. And so 107, as
107.
whoop, sorry, I had some awful. I think probably somebody needs to mute. Okay, move that little window over there. Okay. All right. So under 190, 107, right, this extends to all of our ambulance districts, all of our municipal ambulances, all of our fire-based ambulances, and private companies. And so Cox, Mercy, Abbott, all of those guys can all participate in a mutual aid agreement under 190.107. This statute does several things for us. So it really allows us to enter into those written agreements between any of those ambulance agencies. Also allows us to go across state lines. And so if, for instance, we're in New Madrid County and we would need to reach across and partner with somebody over in across the river, we can certainly do that. Likewise, Marion County, any of those that are neighboring are adjoining with the neighboring state. And so we can enter into those interstate agreements under 190.107. Um, it does if we have a written agreement in place, these agreements satisfy the requirements of 190.105, which is particularly important. I know that so 190.105 is the authorization for any ambulance district to create restrictions on who can practice within their area, what ambulance services can come into their area. And so you may remember back in the early 2000s, there was that major case with Abbott Ambulance and St. Charles County Ambulance, where St. Charles passed an ordinance that said you had to be approved by the district because an ambulance district has the authority to regulate ambulance service within their areas. These written agreements give us an exception to that. And otherwise, we may not be operating with that exception. Also gives us an exception for franchisees. So if you're going into the city of St. Louis for some reason, um, that these written agreements allow us to have an exception to that franchisee requirement. So really important as we're going into other districts. This kind of gives us that background for our mutual aid agreements to go into those other territories without being subject to those restrictions. And then uh, the agents or the agreements can help clarify when and how we're going to respond. And so we want to be careful, ensuring that we're not promising more than we can give. Or the more that we're able to give or willing to give. And so we want to be careful not maybe including language like we're always going to send an ALS truck or we're going to send two ALS trucks or just be careful. We want to make sure and look at the language in those agreements so that we have the flexibility to send what we can. Certainly, we want to help, but we don't want to over obligate ourselves. The other thing with these written agreements, I would say we want to make sure that we've clarified that the sending agency, so that agencies that is responding, has that discretion if for some reason they cannot provide that assistance, that there's not a contractual obligation under this mutual aid agreement to provide that when it's going to be to the detriment of our own jurisdiction. Some of the things that should be defined in these written agreements are, of course, command and control. And so I mentioned that under the Chapter 44 provision, we have to operate under NIMS, in that incident command structure. Those are required by Section 44.090. Um, and so certainly we're going to have an incident commander that's going to be in charge of any disaster or any mass casualty incidents where we are responding to. Typically, the requesting jurisdiction is the one that is in command. And so, regardless of whether they're big, little, it's the agency that is requesting the assistance, the agency where the incident occurs, is typically the one that's in command. Now, they can delegate or appoint somebody else if someone else maybe comes in that can offer more insight or more experience. That's great, but the local control remains with the agency where the incident occurred. That's right out of SEMA's own model agreement, right? And it really matches up with what NIMS and the Incident Command System provides for. However, we should have a representative delegated from each of those responding agencies who's going to work with that incident commander. And so, especially when we go back and look at those written agreements that we might have, we should be careful about who is delegated there as the representative. And we maybe provide some flexibility there because that's a really easy thing. Our administrator retires or moves on. It may be one of those things that does not get updated. Likewise, outdated radio frequencies. These are things that sometimes can be codified in these agreements that we just need to be cautious about updating and refreshing. Um, we want to remember that under the statutory law, and it should be reflected in the written agreement as well, our employees remain our employees, right? And so the employees that are going from our agency to assist another jurisdiction with our truck and our equipment, they are still subject to our direction when it comes to matters of discipline, matters of supervision. All of that is our employment aspects that remain with our employees that remain with us. So they remain on our payroll, which means, if they're going over that 40 hours, they need to be paid overtime, right? They're subject to our discipline, our internal policies, our benefits, our workman's comp. So that incident commander may be giving them direction in the field, maybe telling them where to work, but they are still subject to uh, our direction on how they work. And the same thing when we talk about medical direction and medical control here in a little bit. Um, the other protection we always want to make sure that is in these written agreements, and it's in the state law, but we want to recite exactly how that's going to work, is that as the responding agency, we always have that right to decline a request or to withdraw if we need to come back and cover our own agency. Um, but we need to keep in mind that for us in EMS, there's a specific aspect in there that should be codified because that doesn't mean that we can go, oh, we're down to status zero. Here's the patient, we're leaving. Right? Because if we've established a patient relationship with somebody, we need to make sure that we've completed that patient care or handed that off in an appropriate way before we pull out of a scene. And so we have the right to withdraw from mutual aid if we need to get back to cover our own district. But we need to make sure that our patient is taken care of before doing so. And then the other thing I want to point out, we always want to keep our 911 PSAPs in the loop. We want them to be informed about how these mutual aid agreements function. And that should be something that we've laid out in our memorandum of understanding with our 911 partners, right? So whoever's dispatching us, if we've got an automatic mutual aid agreement in place where, hey, if we're not available, you automatically call this neighboring agency. Obviously, those are things that our 911 partners have to be informed about. Likewise, our first responders, if we've got first responders from our fire protection districts or fire agencies. Everybody needs to know how this process is going to work. And so we certainly want to keep everybody in the loop on that. Some of the protocols, so medical direction especially, often comes up that is an area that may not be touched upon if we've gone online and downloaded a mutual aid agreement, or we've borrowed a mutual aid agreement from one of our fire department agencies, or pulled something out of a file somewhere that there was a template from somewhere else, right? It may not say anything about medical direction. Um, because we operate in EMS under the authority of a medical director, right? And that director has given us certain treatment protocols and directions on how we're going to treat our patients. Those standing orders define what our EMTs and paramedics do in the field, what medications we're going to administer. And those may be different from agency to agency, obviously. And so we may do RSI, our neighboring partners don't do RSI. We may carry certain drugs that they don't. We need to make sure that our written agreements provide for how our paramedics are going to treat patients when we're in our neighbor's territory, right? And so generally, it is our own protocols that will follow us. That's not necessarily what has to be the case. It is possible that responders could, by agreement, then be subject to the other agency's protocols. I don't think that's generally a good idea, right? Because we want our crews typically know our own protocols pretty good or pretty well. They may not know the neighboring agencies as well. And so, um, especially that just needs to be codified in the agreement, right? There's also a lot of EMS folks who work in multiple agencies. And so I would remind your personnel that if we've got a written agreement in place that says we're going to follow our own protocols, well, even if they work for that neighboring agency, if they are responding in our truck and wearing our uniform, they need to follow our protocols, right? If that's what the agreement says. And so if we are an agency that does not use RSI and they maybe also work for this neighboring agency, that doesn't mean they can mutual aid over there and then in our truck with our uniform on do RSI, right? Because they are still subject to our own medical control. Um, so we need to keep that in mind. It may be appropriate, and this may be one of the things that the agreement should flesh out. Might make more sense to use the receiving agency's destination and diversion practices, right? Because which hospital and whether one is closed to new patients and where we're going to transport patients to, that maybe makes more sense to follow the host jurisdiction rules because it really kind of encodes that local knowledge, that local practice that I think makes more sense, right? And so that's easy enough. This is where we're going to take our patients. But again, one of those things that written agreement should flesh out. For mass casualty plans, generally, there is a when there is a mass casualty event, oftentimes there's a mass casualty triage plan. And so then everybody on scene needs to be following that same triage plan, right? We should not have different triages. That doesn't make sense. We got 50 patients. They all need to be treated in a uniform and consistent manner. I do think that it's good for your medical directors to sign off on these mutual aid agreements, just to highlight any potential points of friction, anything that they may recognize. Hey, there's going to be an issue with this neighboring agency. This is how I want you to do things because you are acting under my medical direction. So, a good opportunity for them to review that there. Liability and immunity, of course, are something every lawyer loves to talk about, right? And something that in EMS we don't necessarily want to ever hear about. And fortunately for us, the statute provides that, as I said, those immunity protections, so sovereign immunity for our agency, for our district, is going to follow us as we respond to the neighboring agency. And so, of course, sovereign immunity is that legal principle that Our government agencies can't be sued under civil law for strict negligence. So there's, of course, some exceptions. One of those major exceptions are for motor vehicle accidents. And so we should keep in mind if we are sending a truck a long way across the state or anywhere, there is a motor vehicle exception to that sovereign immunity provision. Our vehicles, just as they would be in our own jurisdiction, are, of course, the biggest exposure in EMS. I say that time and time again. We don't get sued, of course, hardly ever for patient care decisions or patient care mistakes. Our most likely occasion for being sued is going to be an automobile accident. And then our second most likely opportunity to be sued is going to be in patient refusals. But we're not going to talk about those today because usually we're not refusing care during mass casualty incidents. But our motor vehicle exception that exposes us to liability is certainly the biggest exposure in that drive to that other scene, not necessarily in the care that we're providing. We want to make sure that in our written agreement, each party is bearing their own responsibility for that drive. And so we don't want any confusion that if we're responding to our neighbor, that then, hey, our neighbor's somehow on the hook for what we do. Right? That's not to say, because I've gotten calls from folks that have had citizens call and complain that, well, your crew did this or they did that. And turns out it was a neighboring crew, neighboring agency that was in there for mutual aid. So we may still have to hear the complaints, but we want to make sure that there are the appropriate provisions in our written agreements to ensure that each party is bearing their own risk. We do want to be careful with those provisions, though, because one of the ways we can eliminate that sovereign immunity, and we don't ever want to eliminate sovereign immunity or official immunity, is by having an improperly worded indemnification clause. And so we really want to be careful. Make sure your legal counsel is always reviewing these agreements so that we're not inadvertently waiving sovereign immunity and making us responsible for something that we would not otherwise be responsible for. So, especially careful if we're, pulling those templates offline because, Google AI may not know the Missouri laws, the Missouri language there, and may get you the language from Wisconsin. I don't know specifically about Wisconsin, so I'm not picking on them, but get you language from another state that ends up being a significant issue then in your agreement. So make sure we're always having legal counsel review those. Workman's comp and insurance. I mentioned Section 44.090 provides that really explicit language in the statute that says if our medic is injured or killed in rendering aid in another jurisdiction, all of those benefits go with him or her. But we want our written agreement to confirm that in writing and define exactly what is covered in that rendering aid. Because, if somebody's injured, if we're mutual aiding, and we may not be mutual aiding lights and siren, right? But there's a flood or a tornado in southeast Missouri, and one of our trucks is on the way down there. And they're in an accident, we want to make sure that we've defined that mutual aid to include the drive there and the drive back. If we're doing joint drills, we want to make sure we've defined that mutual aid to cover that so that it's really clear that they're working for us, they're acting on behalf of us in this, and that they are still covered by work comp and our insurance. Subrogation is, of course, where the insurer pays a claim and then goes and sues somebody else to get their money back. And so we want to make sure maybe we've got some provisions in there to waive subrogation because we don't want our neighbor's insurance to pay out the claim and then all of a sudden be suing us to recoup their money. That can obviously cause some hard feelings between districts that really don't have any control over what their insurance company does, right? We don't, unfortunately, we can't control our insurance companies, but in these agreements, we can waive some of those subrogation claims. So make sure that we've taken a look at that. And then if there are insurance certificates that we've got, we just want to make sure everybody's covered. So there may be an agreement in that written mutual aid agreement to exchange those on a regular basis. And then finally, we want to make sure our volunteers are covered. And so under the state law, coverage for volunteers actually isn't automatic. So we want to make sure that, especially in our rural areas where we may have more volunteers, if our volunteers are responding in a mutual aid, that we've again got it in writing to just verify and clarify that that coverage is following them. Of course, money and patient billing, this reimbursement aspect is another point we definitely want to have clarified in these agreements. Um, that is pretty important to flesh out there. So there are several models of mutual aid. Probably the most traditional one we're familiar with is the free mutual aid, right? The two neighbors that, hey, we just whenever you need another truck, we're going to send our truck over there to call or to respond to the call. So your three units are out. We're going to send one over to take that fourth call. That's great. That's what we've done for 30 years. We make sure we respond to the calls. That's excellent. Certainly, if that's working well for you, I'm not picking on that at all. I think that many of our agencies use that free model. Sometimes there's what we might call a hybrid model. So, hey, we're going to respond and assist, basically just like that free model. But you know what? If we get past 12 or 24 hours that our folks are stationed over there, because we've got some sort of mass casualty incident, then after that, we have to start charging for that. Or maybe there's a threshold of, we're going to mutual aid over and respond to and cover. But hey, after we get to 30 mutual aids in a year or 50 mutual aids in a year, then we're going to have to bill for that, right? And so those hybrid models definitely take a lot of discussion and dialogue with other agencies, but can provide some options like that. Then there are also just our strict reimbursement models, and so hey, every time we realize that we're likely to get back $600 from Medicare for these transports, but our cost per call is $900. So every time we come over and do a mutual aid call, you're going to have to reimburse us $300 to make up that difference. That's certainly possible. FEMA, of course, provides some auditing assistance there to help us kind of determine some of those disaster costs. And those written agreements can help unlock some of that FEMA assistance when we have some of those national or statewide emergencies. So definitely just things we want to review our agreements to make sure there are provisions for that in there. And then for patient billing, we certainly want to have an agreement about how our patients are going to be billed. If we've got again, I mentioned an ALS intercept or a mutual aid. We don't ever want the patient to get bills or two conflicting bills or two claims for one single transport. And so we want to make sure that billing, that process has been outlined in that written agreement again, because it's not something that comes up on scene, right? It's not something that is brought to our attention when we're helping the patient. That's one of those after action things that can then sour the relationship down the road. And so, just kind of wrapping up here, I think we're almost to our 50 minutes. So, kind of the things that I would like for all of us to maybe kind of take away as an action plan is I would encourage you to start by inventorying every agreement that you have. And so these are written agreements, and we know that they should be written agreements. But we know that written agreements have to be records of the district. They should be approved by a board resolution. There should be board minutes approving them, authorizing somebody to sign them. And so I would encourage you to pull your agreements and make sure that's the case. Because if you have a mutual aid agreement that your chief or your administrator signed 20 years ago, but was never approved by the board, or you can't show where it was approved by the board, chances are that agreement's not enforceable. And so when you have an insurance company, because it's not going to be your neighbor, right, that's going to probably be suing you under that, but you have an insurance company saying, no, I don't care what your written paper says because it was not a valid agreement. Well, we want to make sure our agreements were valid, right? So I would inventory all of the written, the mutual aid agreements that you have in place. And also, if you've got verbal mutual aid agreements or just assumed mutual aid agreements, keep a list of those as well, because I think those are good things to follow up on, and just go back to and say, hey, what we need to talk through this and maybe make sure that we work toward getting a written agreement that's going to clarify everything. Please make sure as you leave here that your board has a mutual aid policy. As I said, for ambulance districts, the statute allows our administrators, our chiefs, to make mutual aid decisions only when the governing board has adopted a mutual aid policy. And so, if you're an administrator who's been relying on that part of without a written agreement, please make sure that your board has a policy because otherwise you are probably in no man's land exercising that authority. So make sure your board has a mutual aid policy. If you need any assistance with that, of course, you're free to reach out to me or your legal counsel, and I'm sure that they can help you get something in place. We also want to review all of our written mutual aid agreements. And so, along with your certificates, I'm going to send you kind of a checklist I've put together. But some of the highlights we want to pay attention to make sure that those indefinite mutual aid agreements have that 60-day cancellation provision, that there is a written provision in there saying that we're not reducing our staff because of this mutual aid agreement. And then we want to carefully look at those indemnity provisions. But I'll send you that checklist, help you kind of go through. Of course, as I said, you can also always send it to me, send it to your legal counsel to help review those as well. But please, as you walk away from today, figure out what agreements you have in place. Make sure you've got that board policy and then review those agreements, just kind of freshen up, see if there's anything that needs to be updated. Going forward, please track and monitor your mutual aid. I would encourage you, as an administrator, to report that regularly to your board. Hey, this is how much mutual aid we're giving to other districts. This is how much mutual aid we're getting, right? I think those are two very important metrics. Of course, as you may remember, last year the state adopted a new statute, and the State Advisory Council, the Legislative Committee is still working on the regulations to enforce that, but it says that there is a presumption that you are not fully staffing your service area if you require more than 10% of the calls in mutual aid. And so just be cognizant of that. Certainly that's a really arbitrary number. I'm sorry that that's in the statute, but I think it's good for you to know where you're falling. And so certainly communicate with your PSAP partners, those 911 agencies, because if we've got that automatic mutual aid in place, right, they may never even be telling us that, hey, we had to call your neighbor for this call. Well, we need that information, right? And so at least on an annual basis, please report back to your boards about this is the mutual aid that we've been giving and what we've been receiving. And these are the agreements that we have in place. So, as I've said many times in our board training, if something is important to us, we track it and we keep a record of it and we monitor it. And if we don't track it, if we're not paying attention to it, if we're not looking at that metric, then I think that's an indicator that it's not really important to us. And certainly, mutual aid is a great thing that we do in EMS. It's a great resource that we can provide to each other, but certainly something that we need to be tracking and monitoring. All right, so that is all I have. I think that brings us to 54 minutes. So Does anybody have any questions? Think you can raise your hand, or there are some other folks here I think came in a little bit later, so I will allow you to talk if anybody has questions. If not, that's certainly fine. I appreciate you being here. Please remember to I guess I can stop the screen share, right? So you can just see my face. Um, Please remember to do the survey online and submit your name and email so that I can make sure you get the uh, Brandon raised his hand. So make sure you get your certificate um, for attending today. You get an hour of continuing education for administrators or an hour of continuing education for board members. And so let me see. Brandon, I see your hand up. So there you go. Can you talk now?
Yeah. So
Oh,
my question is with like I'll just use us and Howard County for example. We have the same medical director. However, we do not carry the same medications. We don't have the same equipment, and like RSI, for example, it's RSI is written in the protocol that we're allowed to do it, but to my knowledge, Howard County does not do RSI at this time. So when you are writing your mutual aid agreement, how does that work? Because we already have the same medical director, and the protocols are all built exactly the same if you pull up the protocol manual, but there's nothing on our end that says how we can operate differently, I guess.
so the presumption is that, and just keeping with your example, right? So if Cooper County comes into Howard County, your clinicians come up here, then they would follow the protocols that Dr. Stilley has approved uh, for Cooper County, right? Regardless of whether they're in Cooper or Howard, they're going to follow their protocols. If and I'm trying to think, well, we have Cameron, right? So Cameron sometimes works for Cooper and sometimes is a full-time employee at Cooper, but I think sometimes works up here at Howard. So what Cameron should not do is be on the Howard truck, mutual aiding to Cooper, and then saying, well, I know how to RSI, right? And we're in Cooper County, so Dr. Stilley has said we can do RSI. If he's on the Howard County truck in the Howard County uniform, he's subject to those protocols. Now, your written agreement can accept that, right? Or change that and say, you know, if Howard County is in Cooper County, then they're going to be governed by our protocols. I don't necessarily think that's the best way to do that, but certainly the agreement can provide for that. So I think the default would be your truck, your agency, your uniform, your protocols. That's what you follow, whether you're here or there. But you can amend that by a written agreement if that's what you wanted to do. Does that make sense?
Yeah. So I guess let's say like we have Kepra, for example, and that is in the protocol for Howard County to use Kepra as well. There's nothing in the protocol that says that they can't, except for the fact that they don't physically carry it.
So,
And so, go ahead.
okay, no, you're fine. I won't cut you off. You keep going.
So, when let's say, Howard County comes over and is helping us with an incident, and we have drugs available to them. They have a protocol for those drugs, but like we don't have anything. Let's say Howard County had, I don't know, let's say they had Kepra and we didn't. We still have the protocol for it, but there's nothing at my service that says that the employees here cannot use Kepra. We just wouldn't have it on our truck, but say Howard County does because our protocols allow us to use it. I don't have anything saying that we can't use it. We just
Right.
wouldn't carry it.
Well, and that could, I mean, that could come up certainly like in a mass casualty incident, right? I mean, maybe Howard County responds or Cooper County responds up to Howard, and Howard's out of a drug, right? Because we've used it all up. As
Right.
long as you have the protocol, I'm not as concerned about whose drug you're using, right? Or who actually owns the drug. But you have to follow your protocol in doing that. And so
Okay.
if Cooper County's got the protocol, but Howard County's got the drug, well, you jump in and then you can use Howard County's drugs on the call.
Okay. That was my only question.
Thank you. I'm sorry. I feel like I took a long time to get around to maybe
No,
answering
no.
that, but that was a good question.
Okay. Thank you.
Any other questions? All right. Well, then I'm going to uh, get off of here and say thank you guys for tuning in this morning and listening to me. I always appreciate the opportunity to talk with you. We'll have, I know, another regular webinar, I think not in August, so it'll be in September, and I will look forward to seeing you then. If there's anything I can help you with in the meantime regarding your mutual aid agreements, please don't hesitate to reach out. As I said, I will send you that checklist along with the survey. So, or not the survey, along with the certificate after you do the survey. So, you guys have a good day.